Welcome, friends, to the India ADR Week discussion co-hosted on this occasion by the Nani Palkihvala Arbitration Centre, and to all the friends who are joining online currently and those who choose to view the recording later. This is an opportune moment to reflect on some of the significant changes that we are seeing in the arbitration landscape. We're joined today by a stellar cast of speakers. Before that, just a 10-second introduction of myself. I'm Shreyas Jayasimha, Actors Counsel, Citizen Arbitrator, trained as mediator. I run Arna Law in India, and I'm in Singapore called Simha Law. The illustrious panelists today include Payal Chawla, the founder of Just Contractors, an all-women law firm specializing in commercial laws. Payal's expertise is in arbitration, and her firm was photographed by the Pulitzer-nominated photographer Lynn Johnson of the National Geographic as part of their 100-year celebration of the U.S. suffrage movement. And we serve as directors on the board in Nani Palkihvala Centre. We also have Renu. Renu Gupta is a disputes practitioner with a focus on commercial litigation and arbitration with over 16 years of experience. She runs a boutique disputes practice called Olive Law with offices in New Delhi, Bombay, and Bangalore. And again, it's with 4 partners who are all women. Today, we are also joined by Anirudh Krishnan, a lawyer practicing in arbitration and commercial dispute resolution. He's also the chief editor of Justice Bachawat's Law of Arbitration and Conciliation, and was part of the Law Commission Special Committee which suggested the 2015 amendments. So friends, to kick things off, I'll invite Payal to please, this will be a potpourri of topics and sessions that concern many practitioners. So stay tuned for everything that pops up. Payal, we'll start with your comments on overview of what is a non-est filing in the context of arbitration. What do you mean when you say non-est filing?
So essentially in arbitration, where we have to do a filing under Section 34 in a time-bound manner, which is a 3-month, 30-day period. But what the court says, because in view of this strict timeline, if you try to stop limitation by filing just a bunch of papers, that would be considered a non-est filing. So not only do you have a strict period of this 3 months, 30 days, we also have to make sure that you're not just trying to stop limitation by filing something that doesn't have a wakalatnama or attestation. And I will come to that in a bit. But essentially, this is what the courts, at least in the Delhi High Court, the courts are saying that the mandate of simplex, which was what the Supreme Court said in simplex, is that timeline has to be met. That's essentially what is a non-est filing.
Perhaps it'll be useful to stick with this topic for a bit, Payal. And I see that we're now joined by more participants who are all trickling in. So welcome again. We began with 2 participants. Glad to see it's hit double digits. At least speakers now stand outnumbered. So Payal, what are also some of the defects that people have to watch out for? Because both parties and their counsel, lest something inadvertently is considered a non-est filing. So what are those defects you ask people to watch out for?
So there is some controversy, at least at the Delhi High Court currently, around what would be construed as a non-est filing. Typically, what was, the earlier line of judgments, which was SKS, Shravanti, they had all said that there are 2 aspects to it. There's conduct and what you've actually filed. For instance, if you filed a petition that doesn't have the bare minimum, like a wakalatnama, the statement of truth, it is not attested by the parties, not signed by the parties, or there are, at the time of filing, you filed a couple of papers, which let's say were hypothetically 50, and even the eventual filing have gone to 250. That in a collective manner, if you looked at a petition and it appeared to the court that this was just a bunch of papers and not, only to stop the limitation, and you have not acted in terms of your conduct, you've not acted with appropriate, the words that are used is due diligence and dispatch, or you have just done this merely to deprive the other party by using the very last day and then filed a bunch of papers, that too would, in a totality of these facts, would be construed an honest filing.
So does it apply in your view in equal measure for both court arbitration related court filings and filings in arbitration? And while you answer that, could you also explain the difference between filing and refiling?
Currently, this is only in time-bound proceedings I've at least come across it only in 34 proceedings. Arbitration, I have never come across it personally, so I don't know how that's being, but I suspect a similar view may be taken in other, for instance, in commercial courts, and I know there is some confusion around the periods in the commercial court, but in 34s particularly, because there is a time-bound thing. Now, on the other aspect of filing versus refiling, the courts see it as a difference, because, for instance, in the Delhi High Court rules, once you file, you have a 30-day period collectively in totality and a 7-day period to correct the set of defects. So it would mean that even if you filed in the 30-day period, taking the court's permission, and you have made a correct filing, you can then take the benefit of the refiling, which could take you over the 3-month 30-day period. But as long as it's not a non-est filing. And I also just want to clarify, I had mentioned that there is some controversy now as to what amounts to non-est filing in your previous question, because there was a division bench judgment in Oriental, which has said that a wakalatnama is essential. Now, there had been some controversy that does it only mean that the wakalatnama needs to be filed along with, assuming just a bunch of papers, but the latest line of judgments are also talking about the collective totality in which a filing has to be seen, and also the statement of truth, how that's going to pan out, because still, in my opinion, what I have come across is that it's only with regard to still Honorable Single Judge of the Delhi High Court. So there is some controversy around that issue.
Thank you. And I think it's a very useful segue. Basically, you have said that the 3 months under 34.3 effectively, as long as it's not a non-est filing, could become 3 months and 30 days. Understood correctly?
No, so 3 months is in any case the period that you have to file in. 30 days is the discretion of the court. In certain instances, that the 30 days could actually become 60 days, provided, that's a question of how parties use it. They could sometimes use their conduct to use that additional 30 days, or they could use it just as a measure where you're not the parties' rights are not taken away in a sense, because there are just some defects which are curable. For instance, pagination, like your margins are not correct, that sort of thing.
Now, thank you very much, Payal. And I see that we have now crossed the half century and going up to nearly 70 viewers. So thank you again to all the viewers. Payal, just in summary, for those who've just joined, took us through the concept of non-est filing in the context of arbitration-related court filings, and in particular, Section 34. So if you missed it, you can watch the recording later. But it's a good segue now to you, Renu, because this exposition on non-est and its application, particularly to courts, draws into sharp relief these dual procedural regimes of the CPC and the Evidence Act on one hand and arbitral procedure on the other. So we all note the provision in the Act that says that the CPC and the Evidence Act shall not bind the tribunal. And it's often said that procedure in arbitrations could follow the fundamental principles. So what are your thoughts on these fundamental principles of procedure and evidence?
Thank you, Shreyas. So the starting point for this is Section 19, which really only and only says that the tribunal is not bound by CPC and evidence. It's not restrictive, it's not prohibitive, but all that it says is you're not bound by it. So the question that logically follows is, if you're not bound, what should you do? And today, I'm going to speak only in the context of domestic arbitration. So do not take the comments today in the context of international commercial arbitrations or arbitration seated outside India, where there is better clarity once you have procedural and institutional rules. Now, once you have Section 19 and it leaves you no guidance besides saying you're not bound and the tribunal is free to decide what it wants to do, the question is, what do you decide? You do have ad hoc arbitrations where the tribunals in procedural orders, the initial ones, will give you some guidance. But even those, in my view, fall short of giving you the exact degree of what is the manner of proof that is expected and which will meet the test of not failing an award when it has to be challenged before a 34 court. There are certain judgments which indicate that even if you're not bound by Section 19, you cannot falter on settled principles of evidence in CPC, on fundamental principles of evidence in CPC. And that raises another question as to what are these fundamental and settled principles. So when it comes to evidence, will you say that the basic rules of evidence, which every law student learns, is primary evidence, secondary evidence. So if you introduce secondary evidence in your trial in arbitration without meeting the ground for introducing secondary and not having introduced primary, have you breached a fundamental rule of evidence? If you bring about evidence which is inadmissible as per Evidence Act, are you breaching a fundamental rule of evidence? Those are questions to which, unfortunately, we do not have direct decisions which give you guidance. But as a lawyer who does this, and when it comes to weighing on the evidence in a trial, my suggestion would always be to take the conservative approach, err on the side of caution, and therefore go the whole hog in absence of clarity, which is that you do take all of those principles into account while you're proving your case. You do go through the primary, secondary rules. You do go through the banker's books evidence. And unfortunately, in lack of sort of guidance on this, you will be duplicating a CPC trial. But that is the scheme of things if you do not want to face a situation in 34 where you're asked, how did this inadmissible evidence come about? And I will speak more on this in the sequence.
Thank you, Renu. Just before we get to your next proposed question, what is your view on some proposals that have been floated to have draft procedural orders, number one, or for institutions to suggest them to those arbitrators who need that assistance? You've also seen some articles on this topic written in recent times. Do you have a view on it, and will that help or hinder the process?
I do have a view on this, and I think it's needed, it's progressive. To have a set of guidelines in place in a vacuum is always welcome. It reduces ad hocism, it introduces more certainty, there is more clarity on how parties must introduce evidence, lead evidence, prove their claims, and all of this goes a long way in not sort of assailing a settled award, which sometimes are sort of unsettled because there are gaps in terms of, what ought to have been the right degree of evidence, the right degree of proof. So my view is to definitely go with it.
Thank you. And in terms of burden of proof, what in relation especially to the quantification of claims, this is an aspect which after people look at liability, but when it comes to quantum, how do you then deal with the issue of burden of proof between the two parties at that stage?
Yeah, so this again ties in with the first part of the question, which is if you are in trial before a tribunal who has not clarified the rules of evidence, the degree or the principles of evidence which have been reduced in their sort of rigor, if you do not have an indication that the primary rules of evidence are dispensed with, or that the secondary evidence can be introduced without meeting out the requirement under the Evidence Act, my suggestion and my view is to sort of, again, follow the process. Figure out what is it that you need to prove, how is it that it is to be proved under the Evidence Act, particularly when it comes to claims and numbers and financial figures. I think bankers' books evidence is again a very crucial aspect. There are judgments which have said that, the provision in the Act, Section 34 of Evidence Act says that entries alone don't prove the transaction or don't prove the liability. And therefore, you have to go with the process specified in the Bankers' Books Evidence Act. There have been 2 or 3 judgments from the Delhi High Court where a party succeeded on liability but lost out on quantum because of a certain view that was taken in absence of clarity on the procedure, that should the party ought to have proved its case as per the Evidence Act, if there is an admission of, let us say, quantum by one party, do you stand, do you sort of stop there in terms of proving your case, or do you go further and prove your quantum because you're the claimant? So I think clarity is key. And in the absence of clarity, I think the only fallback yardstick that we know is the Evidence Act and CPC. There is IBA rules on taking of evidence, but if the tribunal has not accepted it as a procedural rule, I don't think it becomes incorporated as an accepted sort of benchmark. I think in the Indian context, the accepted benchmark would still continue to be the Evidence Act and CPC. And in a 34 scenario, the courts will go back to seeing whether you breached a fundamental principle and whether that would amount to a public policy violation.
Thank you for that. And before we go to the next assigned question, what is your view on bifurcation of proceedings between the liability phase, quantum phase? Quite often in domestic arbitrations, it's observed that there is no such separation, and which is why perhaps we are trying to highlight some of these issues which get swept under the carpet, forgotten about, and lead to many oops moments towards the end of a process. So to prevent this, would you advise friends who have joined and want to celebrate the century that we just managed to achieve? So thank you again for all the viewers. But for the council and parties who have now joined, would you advocate a cautious approach and to have a default approach of having liability phase and quantum phase, so that the people who want to conflate the two can do so by choice later on, but at least they have a safe default? Do you have a view on that?
I have a view on that. I don't think there can be a default situation on this, which is segregation on the liability and quantum in all matters, because one key sort of aspect of this would be consent if it comes up as a procedural issue, which it will. So one is consent, and I do see one party wanting to not consent to a division of the proceedings into liability and quantum for whatever benefit they gain from that. However, I think the tribunal perhaps needs to take a larger and a bigger responsibility in this case, where the pleadings indicate a serious assault on the liability front. I think the matter should require a division where there is an initial issue on liability, and the parties don't need to unnecessarily go through the evidence on quantum, both in terms of time and money. It's a significant cost of bringing in experts if needed. So I think being mindful of the business and the commercials of it, the tribunals perhaps should also weigh this in while framing issues, to frame issue on the liability.
Thank you.
This
So
point.
on the final two questions, we'll combine them. Do you believe that absent any guidance in the procedural order number 1, and the theme of today has been to show how critical that order is, but absent any guidance, do you believe that denial should be as per the CPC, and do you believe that proof should be as per the evidence side?
I do, for all the reasons that I mentioned, that in the absence of guidance, the only rule book that we have is CPC and evidence. And therefore, the benchmark that you ought to meet before a 34 court is that everything was in accordance with the settled principles and the fundamental principles. Whether a 65B affidavit is going to be a fundamental principle of evidence or not is going to be a question. Whether primary evidence is a fundamental principle of evidence or not is going to be a question. And if you don't have an answer to that today, I would sort of take the safer view, which is do it instead of not doing it.
The danger, of course, is to introduce all the court procedures which we're trying to avoid into the arbitration process. So hopefully courts or other sources will provide us guidance more clearly as to what are the fundamental principles of procedure and evidence. And moving with that, Anirudh, can I turn to you to ask for your views on a vexed topic, which is, I'm told, coming up for hearing again in the Supreme Court sometime next month, which is a set of decisions going both ways on the legality of unilateral appointments. So could you please give us an overview as to how that issue has reached the Supreme Court and the larger bench that is to consider it?
Thank you, Shreyas. Yes, you're right. This is one of the most controversial areas in arbitration law today. I think the march of the law began with the judgment in TRF, where the clause was rather unique. The clause said that either the managing director of the respondent would either be the arbitrator or would nominate the arbitrator. And the issue was whether the nominee of the managing director would be a validly appointed arbitrator or not. And the Supreme Court took the view that if a person is ineligible to be an arbitrator, to be appointed as an arbitrator, such a person would also be ineligible to appoint an arbitrator. Therefore, the test was not just appointee-centric, but also became appointer-centric. Following TRF, there were various judgments of various high courts which went both ways. Some of them restricted TRF to the facts and said that ultimately you need to only look at the appointee and you need to look at similar clauses to apply TRF. You had another set of judgments that said that any kind of unilateral appointment was not valid. This came to be clarified in the judgment of the Supreme Court in Perkins, where the Supreme Court made it very clear that any kind of unilateral appointment would not be valid, and that TRF would cover any kind of unilateral appointment. It need not be restricted to the kind of clause that you found in the judgment in TRF. Shortly after Perkins came the judgment in Core, where the Supreme Court took a slightly different view, but the facts were also different. So the clause there provided that one party would provide a panel of 3 from which the other party was to pick an arbitrator. And this unilateral appointment of a panel by one party was held to be valid by the Supreme Court. So unilateral appointment of an arbitrator is not valid based on TRF and Perkins, but unilateral appointment of a panel of 3 from which the other party chooses was held to be valid. A bit of a dichotomy. Thereafter came the judgment in Bharat Broadband. Bharat Broadband took the Perkins principle forward. It was a case of unilateral appointment, not unilateral appointment of a panel. But the Supreme Court made one significant advancement in relation to the law by equating the TRF Perkins principle and fitting it within the 7th schedule and section 12 box. Till then, that connection had not been made in either TRF or Perkins, and this connection was significant because what the Supreme Court held was that a unilaterally appointed arbitrator is an arbitrator who is appointed by a party or by the managing director of a party, and since the appointer falls foul of the 7th schedule, the appointee would automatically fall foul of the 7th schedule. Now, what was the impact of this? The impact was that this brought in the section 12 read with 7th schedule regime, which would have an impact on whether such a clause could be waived. We can go into that at a later stage. So therefore, you had one line of judgments. You had TRF, you had Perkins, you had Bharat Broadband. On the other hand, you had Core, and then Core was referred to a larger bench in Tantia Constructions, where the Supreme Court doubted the correctness of Core, and this was followed by another judgment in JSW, where also the same issue came to be referred. Now, most recently, there is a reference in Sundaram Finance. I think that happened about a week ago. I am given to understand, I am not read, the details are not there, even the order does not set out the facts, but I am given to understand that this was a case of unilateral appointment, not a case that fell within the ambit of Core. That too has now been tagged along with the batch. Therefore, this entire issue is likely to be reconsidered in the near future by the Supreme Court. And I think I must point out, while we are dealing with this, there is one more dichotomy which is often missed. So I mentioned the principle in Core, that is unilateral appointment of a panel is valid. Now, there is a conflict between this ratio and the ratio in West Alpine, where the Supreme Court held that such a panel must be a broad-based panel, and in West Alpine it was a panel of 40 arbitrators. So you have that one more dichotomy, whether a small panel is permissible, whether it should be a broad-based panel. Or the only thing I must point out is that Core is a 3-judge bench decision, West Alpine is a division bench. But following the reference of Core to a larger bench, both the Delhi and Bombay High Courts have followed West Alpine and not Core. So this is one more gray area that's there, which needs to be resolved going forward.
Thank you, Anirudh. And your participation in the 2015 amendments itself has demonstrated to you that resolution need not happen only through court judgments. It could also happen through statutory clarifications, which may actually be time and cost efficient in comparison. For example, we've seen in the past 2 days, several counsel appear for the court of the highest court, but to deal with a point which is perhaps could have been dealt with legislatively fairly quickly. So coming to the further questions in the interest of time and also to involve the participants, can I just have a quick plug to remind the participants to please put in their questions. Today we have Payal Chawla, who has from Just Contractors, who has taken us through the intricacies of non-est filings, especially in the context of section 34.3. And we have had Renu, who has taken us through the applicability of the fundamental principles of CPC and the Evidence Act for arbitral procedure in domestic arbitrations seated in India. And now we have Anirudh, who is talking to us about unilateral appointments and their legalities. If you have questions on any of these, please do use the Q&A. Anirudh, back to you. Do you, what is your own personal view on the varying approaches between Perkins, Bharat Broadband on the one hand, Core on the other, and perhaps Western Alpine somewhere in the spectrum in between?
See, I have, I think let me start off by giving a policy-based answer. Now, one of the main objects of the 2015 amendments was to bring in the concept of minimum judicial interference from courts, which means that the scope of challenging an award has been significantly narrowed down and courts must adopt a hands-off approach. But this is possible only if the arbitration regime is blemishless. Therefore, it's absolutely critical to cleanse the arbitral regime to ensure that the policy of minimum judicial interference does not result in injustice. Now, for this to happen, I think what is central to this is neutrality in appointments. Therefore, if two views are possible, that view that is in furtherance of neutrality must be adopted. And in my view, Perkins and TRF do just that. There is a view that TRF results in some amount of judicial adventurism, because when you look at the strict language in the Act, the test for neutrality is appointee-centric. But I believe that by extending this to the appointer, the Supreme Court has helped solve a big practical problem, which perhaps should have been legislatively contemplated. And as you were mentioning, Shreyas, I think it would be a wonderful idea if the legislature now can clarify this position and legislatively incorporate the Perkins ratio.
Right, thank you. There are, of course, as you yourself acknowledged, several opposing voices to that view that you have expressed, not least those who are in the technology-enabled ODR world, who have, for small claims, had a panel of people, then there's hardly any choice given to the party concerned, and there are appointments. So in a sense, following from Core plus Western Alpine, where there's a large pool of people, so the appointer doesn't quite know which of those people but will be actually appointed, but they have had perhaps some role to play in curating that group in the first place. So there is no unanimity in views of the position that you expounded. I do want to give fair warning to the other speakers that I intend to pose some of these questions to you as well, so that we can benefit from your insight, Payal and Renu. So before we turn to that, finally to you, Anirudh, what is your view on the setting aside of an award where the parties had participated in the proceedings on the one hand, and in another case where the parties had chosen to absent themselves entirely, especially in the context of a unilaterally appointed arbitrator?
So the issue here is what is the standard of waiver that would be applicable? Now, if you were to apply the Section 4 standard, then you can have waiver by conduct. So participation would result in waiver. But when you look at the proviso to Section 12(5), that provides a much higher threshold. That is express waiver in writing after the disputes have arisen between the parties. So therefore, by virtue of the judgment in Bharat Broadband, and I was referring to the development in law and Bharat Broadband being quite significant, Bharat Broadband fits in the TRF and Perkins test within the ambit of Section 12 and the 7th schedule, thereby making the standard of waiver under the Section 12 proviso applicable, which is a much higher threshold. Now, there have been judgments of high courts that have interpreted the proviso to Section 12(5), and when they discuss the concept of an express waiver, they say that one party must, or the tribunal must, bring to the attention of the other party the fact that they have a right to oppose this. And thereafter, the other party must consent to the tribunal continuing. And only then would the threshold under Section 12(5) be met. Therefore, applying this test, which follows from the judgment in Bharat Broadband, even if a party has participated through the arbitration proceedings, so long as the arbitrator is unilaterally appointed, the award is liable to be set aside under Section 34. There was a recent judgment of the Madras High Court in Chennai that analyzes this at length. And also, this judgment also brings in one more concept, that is of quorum non juris. So an arbitrator who is unilaterally appointed would be ineligible and would be de jure incapable of acting as an arbitrator, and hence the tribunal would be a quorum non juris. The only way you can cure this is by meeting the threshold set out in Section 12(5) proviso. So I think this position is would follow from the Supreme Court judgments, though there is no direct Supreme Court judgment on the point.
Thank you. So, absent further amendment to 12 and to Schedule 7, what you're saying may well play out. But since that is also not a given, we will have to, I suppose, wait and watch how this aspect plays out. Before turning to first Payal, I'll turn to you right away, Payal. The question I have is not one that I posed to Anirudh, but just picking up on what he just said about express waiver and proviso to Section 12(5). The underlying basis of that is a broad one, I suppose, where you have to put your opponent on notice if you wish to reserve your rights. We see this without prejudice communication. We see this in many other statements made that this is all rights reserved, and some broad language exists. There's also the principle in some forms of evidence where, for example, if there's, before invoking adverse inferences, whether we need to, in the best evidence rule in India, put the other side on notice and demand a document first before you then ask for an adverse inference to be drawn. So the broader principle appears to me to be one of notice, not just simply limited to the express waiver aspect here. So do you have any reflections as a practitioner, Payal, on the extent of reservations that parties should cautiously make, either in correspondence or in pleadings, so as to preserve situations from not disintegrating like the one that Anirudh has pointed out, but perhaps as a broader learning for the 105 participants? You're on mute.
Shreyas, do you mean this in the context of 12(5) for unilateral?
No, I mean it generally in the process of arbitration, because I think we are now moving beyond just the assigned topics so far. So your thoughts on the notion of how cautious parties should be in reservations, and you can begin by certainly talking about reserving rights in respect of 12(5) also.
See, because let me just talk about 12(5) has been fairly contentious in that sense, because that waiver is supposed to actually, if you see the language of 12(5, is supposed to be in writing. And Anirudh can come and correct me, but my recollection is that 12(5 requires to be in writing, but judgments have held otherwise. So it's always, I would say it is always better to err on the side of caution when you are, even prior to the invocation of the arbitration, whether it's in the context of 12(5 unilateral or any other appointments or any communication with the other side, even if it's pre-arbitration, I think it was always better to err on the side of caution, have without prejudice communication on areas that can be seen as a waiver. We've had a recent case, for instance, in which there was the issue of the appointment of an arbitrator, where parties had agreed to an arbitrator. And one side then withdrew the consent, saying we did not know about the background of the arbitrator. And then the issue came up about whether the arbitration agreement is stamped or not. I don't want to get into too much about the case, because I'm appearing in that, I have appeared in the issue of insufficient stamping. So those issues, although that matter is not connected with the issue of stamping, but just to use that, the matter is not part of the 7-judge reference, but the point I'm only trying to make is it's always better to err on the side of caution, put everything that you require, put your requisite disclaimers, so that it isn't seen as a waiver, particularly either by being silent or an affirmative waiver.
Thank you. Before we turn to Renu, did you, Payal, also have any views on the notion of fundamental principles of procedure and evidence? How is that phrase played out in your experience?
So, I agree with a lot of what Renu says. My concern on identifying rules is really, my view actually, not a concern, is that I feel it can cut both ways, like you rightly pointed out. If you have rules, for instance, rules like the IBA, there is also potential for litigation. There is currently, today we are dealing with certain settled principles on evidence, which I agree with Renu are not always clear-cut as to how much of that applies to an arbitral tribunal versus how much doesn't. But I think the introduction of a fresh set of rules may also invite an additional fresh set of legal eyes to it, and therefore a fresh set of litigations.
Thank you. So Renu, we heard Anirudh with his view on how Perkins, in his view, read and following TRF, and then finally clarified by Bharat Broadband, in his view, is the view that should prevail. Do you have a different view and take on this concept of appointments, whether it is bilateral, and frankly, they can be multilateral contracts, as we know. And in that context as well, could you share your experience on the issue of control over appointments?
So I agree with Anirudh's view, and I don't have anything substantial to add except one point, which is that again, from a policy and jurisprudential perspective, parties with consent are opting for an ADR mechanism, arbitration outside court, and either of the party, and in this situation, a party who's lower in the bargaining position, is not signing up for being worse off in terms of the system not being either transparent, or the system, in this case being the tribunal, having been appointed largely by one party. So therefore, if the idea of equality is what the party goes in with, that idea starts from the constitution of the tribunal, and therefore a unilateral appointment kills that at the starting point. And I entirely agree with Anirudh's view.
Great. And before turning to Anirudh, the quick last question to you, Renu. We heard Payal says she cannot comment on the stamping of judgments because she's appearing in the matter, but there is a question on this topic. And so may I request you to address it? Do you have a view that you are willing to share on the issue of sufficiency of stamping and timing of doing so.
I do have a view. I mean, the arguments on both sides, I think by and large are in the public domain, you know, as to what should be the argument for saying that it should be stamped or that it should not be stamped. But I think I would just offer a perspective, which is that when this issue is seen, it has to be seen from the perspective of what are we trying to achieve as an end goal. We are in an arbitration regime, and the end goal that we're trying to achieve is to see whether an arbitration agreement should get obliterated because the main agreement was not stamped, or should we find ways of letting it survive. So my view is that an argument and the several arguments which support the view that the agreement does not die merely because it is not stamped is my view, and that it's a curable defect, and every endeavor that can be done to cure it should be the way to go forward.
Right, thank you, and we'll watch that space. Coming to you, thank you, Renu. Anirudh, did you have any comments on what Renu had said earlier, especially on the question of evidence in and burden of proof when it comes to the question of quantum?
Yes, I agree, and I think it will be a good idea to have a set of model rules in place. But I think ultimately the flexibility must be left with the tribunal as it right now is under the Act. But I think that one aspect that many tribunals ignore is the power to appoint experts. And in many cases, especially when it comes to quantification, I think this power can be used a lot more than it currently is. So especially when it comes to infrastructure and construction disputes, following the judgment in Afcons versus Mumbai Port Trust, where the Bombay High Court has said that you can't go by a chartered accountant certificate unless a chartered accountant is cross-examined. And today, so there was a surveyor report and there was a chartered accountant certificate that was relied upon by the tribunal, and an award was passed, and that award was set aside. Now, in these kind of disputes, quantification is always an issue. Now, you can prove it, and there is detailed evidence that is necessary to prove it. But in the absence of such evidence being produced, a lot of tribunals have simply reject the claims, or there is a level of approximation that is beyond what would be reasonable. The reasonable approach, I think, would be for the tribunal to appoint quantum experts to actually go into the record and quantify these claims, because there are set formulae, there are set methods for quantifying these claims. All that you require is somebody to go through the 30,000 pages and come up with a report. So I think that's something that tribunal should look at a lot more. Yes, certainly having some model rules will help, but don't make those cast in stone.
All right, thank you. And I believe Payal has a question.
Sorry, can I come in? There's one more aspect on this. There's a very interesting case that I actually argued on something that borders this, where the argument was that the tribunal had not looked into an admission, and that an admission shifts the onus to the other party. So the argument was that this is a fundamental rule of evidence, and we had relied upon judgments that laid down this rule to say that these are binding precedents in the tribunal, and hence contravention of these binding precedents would result in a violation of fundamental policy of Indian law. However, the Madras High Court said that this amounts to sort of hair splitting between reappreciation of evidence, and that from this backdoor route of contravention of binding precedent, we cannot reappreciate the evidence, and hence the argument was rejected. This traveled all the way to the Supreme Court, and the Supreme Court also confirmed the order of the Madras High Court, though the Supreme Court was a one-line dismissal. So this was an interesting case where I think some of the issues that Renu spoke about arose.
Right, thank you. So Payal, you had a question, and if you can ask the question and who do you want to direct it to, please.
So Shreyas, firstly, let me thank you for being the moderator and having done such an outstanding job. My question's actually to you because I know that you have some knowledge on this subject. And could you please comment on the emergence of India IFSC as a separate seat and governing law? Could you make some comments on that?
Thank you. Thank you for the opportunity, Payal, and your kind words. And bonhomie is reciprocated here. I'm happy to share that I think we're at a inflection point when it comes to the realization of the legislative and other executive wings of the critically important role that contractual enforcement plays, and especially as we wish to move from X trillion to Y trillion dollar economies, getting this portion right seems vital. In this context, about 10 years ago, we had the creation of the International Financial Centre, initially now located in Gujarat, but emotionally it could be in multiple places. And we've had some business-friendly legislation, for example, in the securities market, and also when it comes to even today's headline, where non-resident Indians and companies can have dollar-denominated accounts in IFSC without requiring a PAN card subject to some declarations. So this regime appears to be developing apace. And what it, in my view, could result in, and I think this is not commented on sufficiently, because the attention is on the amendments to the Arbitration Act, but the IFSC could result in time as having a separate body of legislation than India, that is onshore India and offshore India. So taking a step back, it was the intention of several parties after the fall of Hong Kong to have some other island of English common law being applicable for transaction in Asia. And that's when we saw Singapore come up with its governing law project saying, look, we can provide common law and which is business friendly, but it need not be English. You had other countries such as Dubai and now in EDGM, where you had islands of English common law saying, look, we're not going to try to develop an independent business-friendly aspect of common law, but we will wholesale adopt English law. India, of course, is not going to have English law applicable wholesale soil again. But if IFSC can attract the attention of academics, practitioners, not only from India, but elsewhere, it may well emerge as a choice of law option that parties have, that they can either choose the contracts to be governed by India or in certain situations by India IFSC. Similarly, it may happen if the law of the seat is varied within IFSC due to any amendments that might come from the IFSC into the IFSC Act, that parties might also have independent choices of seat. Currently, they have a choice of seat within India, largely the metropolitan cities and some others. But the law governing that particular seat is largely the same. Of course, there may be minor variations that might emerge due to some high court decisions. But the creation of an IFSC seat is another opportunity to have, let us say, with some blue sky thinking, currently the law is that two Indian parties may have to choose, they choose to seek their arbitration in India, Indian law, although some proponents of the opposite side of that proposition say that PASL is sufficient guidance to say that you can have foreign law applicable, although it was said in the context of foreign seat. But such clarifications might emerge in the IFSC, and if so, that might fast track the idea of creating at least some part of India as a seat for international arbitration. So thank you again for the opportunity to comment. Maybe I should invite the other panelists for their views on this topic. before we call the session to a close. So I'll turn it back, maybe the reverse order. Anirudh first, Renu next, and last word to Payal.
I think I would just like to comment on what you said at the end. I think PASL and the language of Section 28, don't you agree, would take care of the situation, because PASL clarifies that two Indian parties can have a seat outside. And if they do have a seat outside, then going by Section 20, the language of Section 28, then it would also be open to them to opt out of Indian law. Because
No, that's right. That's it. Just to clarify, yes, that may well be the case outside India. Now, the question is IFSC, which is within the territory of India. Whether, and if, let us say there is a clarification, because if there's any doubt as to this is PASL being applicable only for a foreign state. And if there is some part of India that permits this proposition for a class of cases within India, such as an IFSC area, then that might lead to attracting certain arbitrations which are currently taken offshore.
So would that not require, then that would require a legislative amendment to clarify that if two parties decide on having a seat, well, an IFSC seat, which is offshore India, but still within India, you would still, it would still have to be governed by Indian law, because Section 28 makes it clear today that if two Indian parties have a seat in India, then the governing law has to be Indian. So,
yeah, so exactly. My whole point was to say that there is an effort to relook at the IFSC Act. And I happen to be involved in some capacity there. So if the IFSC Act amendments were to proceed, then we might end up having various options over time. But we do not know. It's still early days, but it's ventilating some options that might otherwise not receive much comment.
So perhaps there could be a carve out in that legislation which permits opting out of Indian law if somebody goes in for the IFSC seat. And then you could say that the IFSC Act would be a special act compared to the Arbitration Act, and hence would prevail over that.
Thank you, Renu, and then Payal.
I have a comment on PASL. I have too short a time to explain it properly, but I don't find that to be a very happy decision, for the simple reason that it means that India as a seat is going to lose out on developing jurisprudence on complex matters. Classic example, a matter, Anupam Mittal, the Shadi.com dispute, we're getting a decision from a Singapore court. Why? And why is it that the dispute wasn't before an Indian court? So in this whole process, and I don't hear a lot of people talk about it, is that our courts are losing out on the opportunity to develop some serious jurisprudence on complex matters. We do not have serious decisions which are dealing with complex implications, of whether it's issues on whether an extension of time, has principles interlinked with liquidated damages. All that we get is a reiteration in a 34 proceeding of the award, because the scope of interference is very narrow. So personally, I'm sort of not happy with that approach.
And thank you. And of course, we've seen the Bombay High Court's reaction to the Anupam Mittal case already, and it reminds me of the times when we had Sasho versus Sharma in the UK, and it took one view, and it impacts comity of courts at some stage. Payal, your final comments.
May I just add to what Renu has said? So my only difference with Renu is that I believe that PASL is a very progressive judgment. The difficulty with PASL is the interplay of PASL with the issue of patent illegality. And I have been a strong advocate for domestic, for the patent illegality test to be done away with. This will, I think, serve two causes. It will make India keep its domestic arbitration, which is currently, and I had predicted this, if I may say so, that this is going to happen. And I think that if we are able to retain a domestic arbitration, we will have the opportunity to develop on all jurisprudence, which Renu rightly says our court should develop on the aspect of particularly damages.
Thank you. So I think we've had an enriching discussion today on a variety of topics. I invite the participants who missed the first part to please consider the recording. But Payal, it leaves for me to thank you very much, not only to be speaking today, but also for being the prime mover and organizer of this webinar. Thank you for all your efforts. Much appreciated. Thank you, Renu, for your insights. And thank you, Anirudh, for your sharp insights as always. With that, I turn you back to the MCIA. Namaste and all the best to everybody. Thank you.
Thank you.
Thank you.
Thank you.